It's time for IP in the news. And today we're going to get into a kind of a weird trademark dispute. It's taking place in Colorado. Two different restaurants are using the term campfire. And the first one is called Campfire Evergreen, and the other restaurant is called Colorado Campfire. Right.
I think
and
Colorado Campfire was the first one.
Right.
Was using it first.
Right. And so the funny thing is if you look at the logos, there are some similarities, but they're mostly different, in my opinion. The only sort of similar feature is a picture of a campfire in each logo.
Well, and the script is kind of the same with the campfire word, but they're both restaurants, but they serve different food and they're in different places in Colorado. So
I'm kind of scratching my head as a trademark person looking at this and saying, well, first of all, Campfire Evergreen versus Colorado Campfire, right? I mean, the words are in different places in the names, right? And the test for trademark infringement is similarity in sight, sound, and meaning. They look different, they sound different to me, and Colorado Campfire sounds like a campfire in Colorado. Campfire Evergreen sounds like
it's actually in Evergreen, Colorado. That's why it's Campfire Evergreen. The location is Evergreen.
So but the really funny thing about this is that people are genuinely confused between the two restaurants.
Well, that's what they say.
They say that there's a lot of people calling one restaurant expecting to get the other.
So, right. So she says customers would place an online order with Colorado Campfire, mistakenly show up at Campfire Evergreen to retrieve it. This is what Colorado Campfire general manager said. So there's still phone calls confusing the two eateries. I mean, all I can think of is that people have imbibed substances before they look for
it is in Colorado after all. And when you're hungry, you don't really pay that much attention, right?
No. But they are suing for trademark infringement, and it'll be interesting to see what happens. But the other thing, Richard, that I found was interesting, and you can tell me about this, is that Colorado Campfires filed for a trademark on the National Trademark Register, but they're only in Colorado.
Right.
So can they even get a national trademark if they're just doing business in Colorado?
Well, if they are just doing business in Colorado, they can. If you want a federal trademark registration, you have to be doing businof in interstate commerce,
which most people are these days. But
yeah, I mean,
if
they have customers coming in from out of state or something, or if they're close to the border, then it's possible. So
anyway, so I think the takeaway is just be careful what you name your company and try not to get confused with anything else. But I do want to also give credit to the person who wrote this article. It was on Westword. It's Denver's independent source of local news and culture. And the author was Amy Antonation, and they published it on August 8th.
Right. So anyway, it's time for Richard's Roundtable. After all of that, I really hope that you have a few comments. Mike, you're up first. Welcome to the show.
Thank you so much for having me, Richard. Thank you. Elizabeth, thank you.
It's an absolute pleasure to have you back. So what do you make of all of this?
I think it's Colorado, right? Hey, they made it legal. People are getting confused. It is what it is.
Rocky Mountain High.
Some people get confused walking in their own door. I just don't understand it. There's obviously no correlation between the two. They're not near each other. I'm confused as to why people are confused, so.
You said it perfectly. I'm like, why are people getting confused over this, right?
That makes no sense to me at all. But, I was thinking about what you had said about the national trademark, Elizabeth. Such as the other guests that we have here today, they market on the internet. Now, that gives them a global presence. Mm-hmm. Does that make any difference when it comes down to trademark infringement or getting a trademark?
Sure. So having an internet website in and of itself doesn't give you business and interstate commerce, you really have to have customers that are, logging onto your website, ordering stuff, or you have to be shipping to people outside. But just because you, the state, just because you have a website in and of itself does not give you enough of a right to get a federal trademark.
But with SEO and, some of the things that they're able to do online with marketing companies today, isn't there a way like on the front page of listing other states so that people will find you?
Right. And it's pretty much presumed that if you're on the internet, it's your website is available globally. So the question is are you really doing business with interstate? So if you're advertising and targeting a particular region for potential customers, that could work. But if you're just using keywords that are more generic in nature, it's a tougher sell. It is really fact dependent. So
Right on. Right. Yeah. When you said people sue, these guys are suing each other and the one guy's suing the other guy. People could sue for anything these days. I mean, and people get offended over everything. And I just wish there was some kind of law or some kind of bill passed that could kind of suppress some of that, because I think it's a little bit out of hand these days.
Yeah, I mean, I agree. If you think about how much business the other side is losing because of this, or whether they're gaining, people have spent a lot of money on advertising and investing in their brands, so they get annoyed when somebody else, there's a sense that maybe somebody's trying to copy them or trade off their goodwill. I mean, a lot of disputes are just purely emotional. Like we don't know the backstory of how often the restaurant owners went back and forth complaining to the other person, and finally somebody just said, hey, to heck with it, I'm going to sue this person. I've had restaurant cases in the past that are very similar, where the owners of the restaurants went back and forth for 10 years telling the other one to change their name, and it just turned into a big ego contest, and eventually there was a lawsuit. So it's really weird how these things evolve, and it's not always a matter of common sense.
Now, here's one case where I wish there would have been a lawsuit, because Richard and I went out to Sedona, Arizona, and we had his assistant book the hotel, and there were 2 hotels with Adobe in the name. And we ended up
in the bad Adobe hotel, not the good one, the bad one.
There was definite confusion there.
So Adobe is not just another application.
No, it's not just another software.
It's actually a town. So,
Now, as for lawsuits, I mean, we all heard about the McDonald's case years ago, or even I think it was Wendy's just recently, where there was a cup of coffee that was spilled on a person's lap, and they were claiming 2nd and 3rd degree burns. I can imagine what would happen with Rachel and Mark's chocolates if they were to ship out in the middle of August, sending them to me. I would have 4 lawyers calling them saying, my chocolate hazelnut melted, Mark, and it's your fault.
Well,
how are you going to fix this?
That's why we put a disclaimer on our website. And I want to circle this back to what you were just sharing about, Richard. Nobody reads.
No, of course not.
So that's really, I think, what's happening with the Campfire dispute there is nobody's really reading. So, and we notice that because we get shipments all the time, and we say it's your responsibility if we ship you chocolate out west and it's 90-degree weather. But
yeah, and then as a business owner, what do you do under those circumstances? I guess you just eat it, right? If you pardon the pun.
Hey, I'll eat melted chocolate. I'll eat chocolate in any way, shape, or form. So.
Yeah, right. It doesn't matter to me if it's melted. I'm down for it. However, so Carolyn, what are your thoughts on all this?
Yeah, so I actually think that if I had a business that was experiencing something similar that the restaurants are, I would turn the negative into a positive, and I would look for a solution rather than blame somebody else. Clearly, the names are not in the same order. There's a lot of differences, but I'm going to go with Rachel and say that people are in such a hurry that they aren't really truly paying attention. We're all in a very distracted world. So I just feel that if I were the restaurant owner, and I hope maybe they might be chiming in or somebody who knows them, take the negative and try to figure out what the solution can be. So if your hostess is answering the phone, taking takeout orders, make sure you clarify which restaurant you are. Say, just confirming you're coming to this location. If they're ordering online, put in big bold letters, maybe right under the restaurant name, please make sure you visit us at this location. I think there are a lot of things that they could be doing with their money and their energy to turn it into a positive situation, because anytime I feel there's any negative energy brought into my life or my business, my family, friends, whatever, it's a major distraction. So that's my thought on it.
That's brilliant. You know what? They could also partner up and give each other a referral fee or something,
Right. I mean, it's
brilliant.
it's
Carolyn.
really, yeah, I couldn't agree more. And
Yay.
in my opinion, even as an attorney, it's silly that they're wasting their money on this.
Yeah.
And
Sure.
lawsuits, especially for small businesses, take a lot of time and they suck a lot of energy. And you just go down this rabbit hole of negativity, right? And sometimes that's the way it has to be. But to be focusing on what's going on with your competition in that kind of way, to me, is they're losing their momentum.
Except they
potentially.
are getting publicity on a nationally syndicated radio show.
Well, I bet they planned that, right?
So they are getting written up in the paper.
That was part of their plan all along.
Maybe it was just a marketing strategy.
Yeah, I was going to mention that because I had a cupcake bakery back. We opened in 2005. And with the previous employer, I had signed a non-disclosure and a confidentiality agreement. And within 6 months of opening, we were getting sued by my previous employer, saying that, I stole her idea, I stole her recipes. And Richard, I'm sure you know that recipes cannot be trademarked. She took us to court, and it turned into a media circus for us. It started what was called the Cupcake Wars here in New York City. So it was our bakery, and then it was Magnolia, which is the biggest cupcake bakery in New York, and then another bakery. And we were the new kids on the block, and we had a huge front page article in New York Magazine, and it put us on the map in very good company. And sometimes I wish we would get sued more often in that. Because
I'm sure we can help you with that. If that's
Richard, I'll be your guy.
That's a great story. They can't be trademarked, but they can be patented sometimes, the food recipes. So we actually patent quite a few food recipes. Yeah.
But in this case,
Yeah.
though, it sounds like it was just a big mess. But like you said, getting publicity in the New York Times is probably turned out to be a positive. And I assume that you eventually ended up settling this or doing something like that, or did it go to trial? Or
it was thrown out when their lawyer started arguing that we stole their Rice Krispie treat recipe. The judge threw it out at that point.
Oh my God.
pretty much lost it at that point.
Yeah, I wasn't in the courtroom, but I wish I'd seen the look on their lawyer's face.
Yeah. The old Rice Krispie argument never wins. I can tell you.
No,
from
you're not going to
experience.
win that one. Yeah. But even closer to home with Eigner chocolates, we take our name from the family that we took over the business from. Their family name is Eigner, and they're Austrian, and they've owned it for 3 generations. And this is before we took over the business, but we were told that the shoe company Etienne Agnier sent a cease and desist letter to the owners back in, I guess, in the early 2000s, because they thought that they were taking their name. And from a shoe company or a fashion company, to chocolate company, completely different. As soon as they were able to prove that this was their family name and this is what they named the chocolate shop after, that was pretty much squashed also. So
yeah, that's a stretch.
Names are really important. So, but now I think that was a great discussion. Thank you, everybody.